Today's film is dedicated for a shmir for the Chayalei Matzah for the Shvuyim and Yeshua for Am Yisrael and it's Sarah. We're going to start. Today's film is 159, but we're going to start on the bottom of 158b, 4 lines from the bottom, 158b. So the Gemara says, Shalchol mitam, they sent a message from Eretz Yisrael to Bavel, Ben Shalava b'nechsei aviv, if there's a son who borrowed the assets of his father, b'chaye aviv, while his father was still alive, umeis, and then he died, b'no motzi miyad kuchos, the son can take it away from the purchasers. V'zui shekasha b'dinei mamanos, and this is one of the most difficult laws of the monetary laws. So first of all, the law makes no sense. Lova my mapik. What is the borrower doing to get the property away? Why is he getting it away? And also, what do the purchasers do that they're going to lose the property? So the Gemara says, Eliyat Marhachit. The Gemara is going to give 5 suggestions as to what this could possibly mean. Number 1, Ben Shemachar B'nechsei Aviv B'chai Aviv. Let's say you have 3 generations. That's how Rashbam explains it. You have Yaakov, who's the grandfather, Reuven, the father, Chanoch, the grandson. So Reuven sold his rights to inherit his father. He sold his father. He was going to inherit his father's field, but he sold it while his father was still alive. And then Reuven died. He predeceased his father. Then Chanoch can come. Beno motzim yadol kuchos. The son could take it away from the purchasers, and he could say, "Actually, you had no right to buy it because my father never had it." V'zui shekasha b'dinei mamanos, and this is one of the most difficult laws. Because why is this difficult? Because the purchasers could say, "Avucha ma'azbin, your father sold it to us. You want to get rid of it? No, that's a difficult law." So that's the first approach. And says, "My question, why is this difficult?" Maybe the grandson Chanoch could say, "I'm inheriting it straight from my grandfather." I'll prove this to you because it says, in place of your father will be your children, and you will make him the princes in the whole land. We're on 159a, Bill 159a. And kasha, if it's difficult, this is the difficulty. Ben Bechor, let's say you have, so remember we said there's 3 generations. There's Yaakov, Reuven, and Chanoch. So Reuven is a firstborn. So Shemachar Chelek Bechora, that he sold his firstborn rights. He sold his share in the firstborn. B'chai Aviv, while his father was alive. He sold it to a purchaser. Umeis B'chai Aviv. And then he died before he could actually inherit it. So Beno Motzi Miyad Kufos. The son is able to take it away from the purchasers. V'zu Shekasha B'dinei Mamanos. And this is one of the difficult laws of Dinei Mamanos because Avua Mezabin, your father sold it, and Iyumapik, and we're allowing Chanoch to take it away. Now, if you want to say also here that Chanoch is saying, I'm coming with the strength of my grandfather. Well, if he's saying I'm inheriting it straight from my grandfather, then why is he getting a right to the firstborn? He shouldn't have the right to the firstborn. Gemara says, "My kushya, no, it's not a difficulty. Therefore, the my kushya, why is this difficult? Dilma Mati Amar, maybe he could have said, maybe he could have said, I'm coming from the strength of my father's father to inherit, and I'm standing in the place of my father. My father would have gotten the firstborn, but I'm coming in his place, like Tzlafchad, like we learned several months ago with respect to Tzlafchad, that he inherited also the share of the firstborn. We learned that even though the firstborn dies, his son is entitled to inherit the share of the firstborn. So it's not a difficulty. Eloi kasha ha kasha. So maybe this is the law that they said that was difficult. It's the third approach. Let's say he knows testimony on a contract. before he became the robber. He testified on the contract. He signed it. Benasa Gazlan. And then, in fact, he became the robber. He can't testify to his signature now because he's a robber. But others are able to support his signature and certify it. So he's not believed, but others are believed to testify about his signature. And this is one of the difficulties of the monetary cases. So the Gemara says also here, what's difficult? Maybe his signature was certified right away in the court by a handpick. The courts certified it, like they notarized it. And then the witnesses are testifying that we know that the handpick is valid. If it's difficult, this is the difficulty. The fourth possibility. He knew testimony before about on a contract, and then that property was going to become inherited by him. He can't certify it because he's no gaya to it. He's supposed to inherit it. But others are able to certify it. So the Gemara says in my kosha, same suggestion. It's not difficult. Here too, we'll say that it was certified in the court. If it's difficult, this is difficulty. If he knows the testimony, no. And there's the fifth possibility. He knew the testimony before he became the son-in-law. No. And then he became the son-in-law. He's not going to testify about his signature. But others can testify. He's not believed. But others are believed. Here too, if you want to say that his document was certified in the court, this works even though it can't be certified. Even though his document was not certified, others could testify about his signature. Gemara says, still that's not difficult. In my kusha, why is this difficult? Maybe it's just a decree of the king that states the it's a decree of the king that he's not believed, but others are believed. And it's not because he's a liar, it's just a decree of the king. Because if you're not going to say this, Moshe and Aaron to their father-in-law, where we would say, do we not trust them to testify? Is it because they're not believed? Because they're obviously trustworthy. It's just a decree of God that they can't testify. And here also here too it's just a decree of God that they can't testify about their signature to their father-in-law. So therefore we have to say, we come back, we reject these five approaches, and we say, go back to the initial one. And that which you said, but why is it difficult? The grandson stands in place of the father to inherit the estate. No, that pasuk was not teaching us that the grandson inherits the grandfather. It was teaching us about a blessing. That it's a pasuk that tells us that from Tehillim that the grandfather will be blessed, that they have a grandson who's so righteous. When we matzis amris bebracha ksiv, do you really want to say that this verse only refers to a blessing? We're on the top of 159b. If that's the case, avolenian dinalo, but it doesn't refer to an inheritance. But we have a question coming back to our Mishnah Vatanan, the Mishnah that we had on 157a. Nafa abayis alav. If the house falls upon him and on his father, upon him and upon those who are bequeathing to him, and he has a ksuva that he has to pay, and he has the creditor he has to pay. The heirs of the father say, they say the son died first, and then the father died, and so therefore we don't have to pay it. And the creditor says, the father died first, and then the son, and so therefore we can inherit it. Now, what's this case referring to? My lav Yorsheav. What does it mean when it says the heirs of the father? Isn't that referring to B'nai? Isn't that referring to the grandson? And Morishav Achi. And when we say that those who are supposed to bequeath him, that's his brothers. Now, if you want to say he can't say he's coming in the place of his grandfather, because when it says tachas havasecha, it refers to a blessing. When the son dies and then the father dies, who cares? Let the creditor say, it's obviously the case that it must be that, because they could have said, you're taking your father's inheritance. So therefore, we see from here, from the fact that they don't say that this proves that the grandson does not inherit, that does not inherit from the father. So we see from our Mishnah that they inherit him directly and not through Ruvain, meaning to say from the fact that since it's referring to the son and they can't say that. So when it says that the Yorshei Av, that those who inherit the father are saying that the son died first, that's why they're able to say it. Gemara says no. Yorshei Av, when it says the heirs of the father, refers to the Achiv, refers to his brothers. Morishav Achidavur, and the heirs refer to the uncle, the brothers of the father. So now we have the next question. So they asked the question of Rav Sheshas, Ben Mahu. They asked the question of Rav Sheshas, Ben Mahu Shayirish Asimo Bekever. We already had this discussion earlier. Can a son inherit his father in the grave? Meaning, son inherit his mother in the grave. After the son dies, will he still be able to inherit to pass it on to his paternal brothers? To pass it on to his brothers to his father's side. The mother's heirs. So the Gemara says, Amar Rav Sheshas Tinisua. Didn't we learn this? The father. No, he could have paternal brothers. Those are not the mother's heirs. So that's what he said. So he says, Can the son inherit after he's dead to pass it on to his paternal brothers as opposed to a more distant relative, but it's on the mother's side? So I'm Rav Sheshas Tinisua. We learned this as Rav Sheshas. We learned this in the Brisa. Let's say the father's captured and the son dies in the country he's born. It means to say they both died. We don't know who died first. The heirs of the father and the heirs of the son split it. Now, what's this referring to? If you want to say exactly like the Brisa is talking about that the father and son died and we don't know who died first, and we don't know who will merit it, either the heirs of the father or the heirs of the son. Haininu Yorshei Av, Haininu Yorshei Ben. Who are these heirs of the father? Who are the heirs of the son? Meaning to say they're the same case. The heirs of the son are also the heirs of the father. Who are they splitting it? So it must be that this is what we're talking about in this case. Av Shenishba, father is captured, Umeis Ben Bito Ben Medina, and his grandson through his daughter dies. Uben Bito Shenishba, Umeis Avi. So basically we're talking about a case where it's his grandson through his daughter. We don't know who died first. So Yorshei Avi, Yorshei Ben Yachoku. Then the heirs of the father and the heirs of the son will split it. And so therefore, meaning to say the heirs of the son, the brothers of his daughter's son split it. Vim Isa, and even if it's the case, if this law takes effect that a son inherits his mother in the grave, Ninami de Ben Meis Beresha, even if the son did die first, he still should have been able to inherit his mother in the grave, and to pass it on to his paternal brothers. So we see from here, it's obviously the case that the son does not inherit his mother once he's dead to pass it on to his paternal brothers. So Amalei Rav Acha Bar Minyumi Abaye, so Rav Acha Bar Minyumi says to Abaye, Afanan Nami Tanina. In fact, we learned this explicitly in the Mishnah that a son does not inherit his mother in the grave, because it says in our Mishnah that we had on 158b, it says, the house falls upon him and his mother. Everybody admits that he split it. And if the son will inherit his mother in the grave, even if the son died first, he should still be able to inherit his mother, and pass it on to his paternal brothers. We see from here the clear proof. The son does not inherit his mother in the grave. To pass it on. The time of my, what's the reason why the son does not inherit his mother in the grave? Because it says the word siba. It says lotisov by a son and lotisov by a husband. Just like a husband does not inherit his wife once he's dead, he doesn't inherit his wife in the grave. So also the son does not inherit to pass it on. Okay, this next case, we had word for word, literally word for word back on Daf Lamed. If you remember it, there they did it over several topics. Here we do it all in one dop. It's just a repetition of what we already had earlier. So the person says to his friend, he says, I'm selling to you the assets of Bar Sisin. There happened to be one land that was also called the land of Bar Sisin. Also, there he basically gave him that land. There was one land that was Bar Sisin, and he doesn't know it because there's another land that was just called Bar Sisin. He says this land is not the land of Bar Sisin. It's just called it Bar Sisin. Also, Rav Nachman gave it to the purchaser. Rav Nachman, is this really the case? He's the purchaser. He should have to bring a proof. So Rami, the Rav Nachman is a contradiction between Rav and Rav Nachman and Rav Nachman. Because there's another case. He says, "My bayis b'hai beisa." So there was a person who says, "What are you doing in my household?" He says, "I bought it from you, and I've been here for 3 years. It's mine." I was inside. I was in the inner room. You don't have a chazaka. Also coming to Rav Nachman. So Rav Nachman said to the guy who said, "I was here for 3 years," he said, "Bring witnesses that you were living there only by yourself." So Rav says to Rav Nachman, is that really the case? Then we have a principle on motzi mil chaver olav araya, and here in this case, the seller is the one who's taking it away, and he should have to bring the proof. So in the first case, Rava said the purchaser has to bring the proof, and now he's saying the seller has to bring the proof. Kasha the Rav Nachman. The Gemara says it's not a question. The Rava. Well, Kasha, have a great day, Kobe. Rava on Rava is not a question. Hacha mocher kai benichse. Here in this case, the seller is the one who holds the assets because the land was in his domain, and so therefore, Bar Sisin. And so since the seller still has it, therefore the purchaser has to bring the proof. But in the latter case, the guy who was in the property, he's the one who had the assets. And Rav Nachman will kasha. Rav Nachman is also not contradictory. Since he said, I'm selling to you the Bar Sisin estate, who mikrei Bar Sisin, and this land was called Bar Sisin. The seller has to prove it wasn't the Bar Sisin. But in this case, but in this case, if he has a contract, if in this case, if he has a contract, we wouldn't say you would tell him to bring up your contract and uphold your assets. We will return to you, Misha Meis, this beautiful chapter.